Welcome to another edition of the Corner Booth Podcast here from the Stoughton Delicatessen. I'm Aaron Rand, along with Bill Brownstein of the Gazette, and our guest today, former Canadian Justice Minister David Lametti. David, thank you so much for being here.
I'm pleased to be here. Thank you.
I said former, so let's start with that. This is big news. What you had originally called, and I'm sure still do looking back now, your dream job as Justice Minister in the Trudeau cabinet. Let's start with that. It's a big decision to leave politics and try to cover some of the reasons you decided it was time to leave.
Sure. Look, it was my dream job. It is, when I went into politics, in the back of my mind, I said to myself, boy, if I could ever be Minister of Justice and Attorney General, that would be fantastic. And I got to do it for 4.5 years, which is a long run. I'm up there with Anne McClellan as the longest serving Liberal Justice Ministers in the last few decades. And managed to get a lot done. Got a lot of bills through, 13 by my count. Tabled another 5 or 6 before I left. We're still working through a couple of them. One of them is greatly important to me, the Criminal Convictions Review Commission, the Wrongful Convictions Commission, which I had a chat when I first got named, and with one of my mentors, Erwin Kotler, and Erwin said, this is a good idea, and I had clerked for Peter Corey at the Supreme Court, who did one of the ex post facto reviews of a wrongful conviction, Thomas Sofino, so this was in my DNA. That one's going to get through, I hope. It got through committee yesterday. And so I'm pleased. We managed to get a lot done in criminal justice, we managed to refine MAID, and some I think, very progressive legislation.
So why the abrupt dismissal? Nobody got that from cabinet.
Look, and I can't tell you any more than I know, which is
you didn't like the socks.
Which is I kind of like the socks. I guess I got lost in a numbers game, which is what the Prime Minister said to me. There's a lot of balancing that goes on in.
But in terms of
making.
Efficiency, I mean, this is what shocked people because it wasn't as if you were falling down on the job.
No, I don't think it was because of that, and he did say that he thought I'd done a good job. So I'm, and I was there for some big events,
yes,
which and again provided advice and I think leadership.
And I know, of course, the official is I serve at the pleasure of the Prime Minister.
It is indeed.
We all get that.
Yeah.
But let's be honest. What you said, I think, on the floor when you left to Parliament was, and I want to bring this up because it's the most recent thing that people are looking at, going, wow. That took a lot to say. You said it's time we stop scapegoating the English community in Quebec, and to get up and actually say that, yeah. I'm sure took a lot of guts and a lot of thought and reflection. So why?
Well, look, we have a wonderful dynamic community, Anglophones, allophones who have chosen English as the language in which they want to live, and it's a long tradition. Goes back 300 plus years. In many cases, many people trace their roots back to the Loyalists and others, or English businessmen way back, even in the times of in colonial times. So, community's been here a long time. We're a good community. High level of bilingualism. Most of us can function in French on a day-to-day basis as we're working, and so that's a good thing. I think we're there, working together to help advance Canada, help advance Quebec, help advance the French language, and by being allies. I mean, it doesn't mean we have to speak French at home. Many do, but we're there as allies, and it's every time there's a blip in the statistics, or every time there's a blip in the politics. The easy target is the Anglophone community in Montreal and in the eastern townships and frankly across Quebec, and it's not fair. It's too easy a target. There are other ways. Look, there are other ways that we need to work to help protect the French language, and as allies we have a role in that. And I think we have to work together. I said that in my speech too, that we need to work together to protect the French language in good faith.
You were going to be challenging Bill 21, notwithstanding, and all the rest, and you were very prominent on that front. But you got a bit of flack for not taking a tougher stand on C-13 in terms of the fact that really was only Anthony Housefather, Mark Gardner while he was out, was supporting, and it must have been a tough decision to make to support the government in terms of what you were feeling about Bill 21.
Well, Bill 21, I think there I had my hat on as Attorney General,
Right.
and at the time I thought, and I still think, that the best way to challenge that was letting it go through the court system. People were talking about a reference, but
Can I
it's
stop you
harder
there?
to win a reference.
Can you explain, because I know this has come up before, some people criticized you or the government for not making it a reference case. Why would that not have been viable?
You have one shot at winning this at the Supreme Court, and you're asking the Supreme Court to overturn its own precedent, right? Because in the Ford shoe case, court said in passing that that one could use the notwithstanding clause preemptively. So you're asking the court to overturn one of its own decisions, the Supreme Court, and the Supreme Court has set up some jurisprudence. They did it in the Carter case, in the assisted dying case. They've set up some standards, and so you need to show changes on the ground. That's harder to do in a reference, and any good litigator will tell you that it's also better strategically to let the case build through first decision, an appeal decision. You see what kinds of arguments worked and what didn't work. So that was my thinking at the time. I thought there's a good chance one could lose this reference. In 2 years, a lot has happened. We've gotten a Superior Court judgment. We're waiting for a Court of Appeal judgment. And at this stage, it's my successor, the Attorney General, who is guiding the litigation. But I thought at the time that was the best strategy. I still think that's the best strategy. And again, and if you lose it, you're done until you can make constitutional changes.
I just want to go back and follow up on something we just said, and to the idea of getting up and saying we have to stop scapegoating the English community. You chose to do that as your last speech in Parliament, and people will say that's great, or the English community looks at that and go, you know what, it's great to have someone stand up. You're a Quebec minister.
Yeah.
Why now, not then, when this became an issue?
Well, when you're a minister, your voice is at the table, and I was a strong voice for Quebec, but also for the Anglophone community in Quebec at the table, both in caucus and in cabinet, and people will tell you that. Anthony will tell you that. So, but as a cabinet minister, then you live with the decisions that are made. I want to go back to C-13. I don't completely agree with Anthony in the sense that I think generally it's a good bill. And I think generally in the fullness of time, the Anglophone community here in Quebec will see that it was a good bill. There's a lot of things enshrined in that bill that are I think, very positive and proactive for the Anglophone community. So, for example, enshrining the fact that the federal government has a role in protecting minority languages across Canada, including French outside of Quebec, including English within Quebec, but also including French in Quebec. And that's something that your previous guest probably would not agree with. But that's there in C-13. There's also something that may play a more important role moving forward, which is an obligation or recognition that the federal government has a role to play or an obligation in protecting minority language institutions. And again, that's a critically important part of C-13. There were some parts that, as the bill evolved, there were references to the Charter of the French language, which at the outset, I think were fairly common sense. But as Bills 21 and 96 came into play, there was an argument out there that somehow Bill C-13 was endorsing those pieces of legislation or the preemptive use of the notwithstanding clause. And I don't share that view. I understood the symbolism of it, and so I worked with Anthony to try to make those changes at committee. I worked behind the scenes. Anthony obviously worked. He was on committee and was working, but we were working together to try to make those changes. I think they were symbolic changes. Anthony thought they were more than symbolic changes, and so he took a different position at the end.
Seems to me at some point we thought, or it became an opinion, I think, I certainly heard it from listeners, that when Bill C-13 was introduced, we were going to get to a point where, as an Anglo, you could not walk into a federal institution, like a bank, for example, and be served in your language.
Right.
Because it would mean you worked there, you'd have to speak French, you wanted to be served there, you had to speak French, and the right to be able to speak English would be lost. Was that ever a concern?
The bill itself the bill itself, I guess, allowed for the greater use of both languages, I would say, but in Quebec, obviously, that often means French in a number of different institutions and federal institutions. So prior to C-13, the provisions of the Quebec French language charter didn't apply to federal institutions. What we did in C-13 was create a parallel regime and allow for people to choose. And what we were doing there was protecting the right of people to work in their language. And it was the case in a number of these institutions that Francophones were being forced to work in English. And so we're trying to protect the rights of both. That's not its intention is to not take away the rights of Anglophones to be served in English in these institutions. And I think on the ground it will stay that way. Again, there were, and that I think, and I'm pretty certain now, looking back, that's something that we all agreed upon, and Anthony included. Although Anthony did work hard to make a few pointed amendments to that bill as well, and on that part of the bill. And look, he's done great work, and I valued him as a colleague and as a friend as we worked through this. I think C-13 got a lot of bad press because of the timing of it. If it had come out not in the context of 96 and 21,
sure.
I think we would have had a different narrative on C-13. That being said, we'll see in the fullness of time. What I said on Bill 96 at the time was that I would defend any incursions into federal jurisdiction. And that I would continue with 21 to fight the preemptive use of the notwithstanding clause, because that was being used to protect what would otherwise be charter violations in provincial areas of jurisdiction. And I maintained a vigilance there, watched the court system in particular, because that's one of the parts that's protected under the Constitution, and it's not in any way touched by the notwithstanding clause. And there were some questions that I was watching carefully while I was Minister of Justice, and I expect my successor to do the same thing.
The Corner Booth podcast is brought to you in part by the Snowden Deli, serving Montrealers since 1946 and home of the city's best smoked meat sandwich, the Snowden Deli, DeCarry Boulevard, north of Queen Mary Road.
You decided to quit Parliament altogether.
Yeah. I
know a lot of people in your riding were very big fans of you. And what was that decision about?
Well, I love the riding. I had done 8 years. I found it difficult after I got left out of cabinet. I've said that publicly. It's a big change in your life, and I did my best. But I really had trouble finding my sea legs again, being an MP. And there are things that I think we need to look at. There's even a question of I had a long discussion yesterday with a colleague, but there's even a question of the pretty strict set of ethical rules that you have to follow once you leave cabinet about contacting cabinet ministers. And as an MP, you do that all the time. Now, there's a bit of ambiguity in the current conflicts rules whether that applies to cabinet ministers, ex-cabinet ministers who are still MPs. I suspect that I was fine speaking to my former colleagues in the interests of my constituents, but I found that it was hard to find those routes again to be effective as an MP. And I did mean what I said in my resignation communique, that I think the riding would be better served by a change of voice.
So I want to, if I can, just go back a little bit. I remember when we spoke a little while ago, and I asked you, about 5 months ago since the demotion, and saying to you, here you are in your dream job, and then suddenly the Prime Minister, at whose pleasure you serve,
that's right,
cuts you off at the knees. Beyond being disappointing, was that a seminal moment for you when you said, you know what, maybe my career, maybe my job ought not to be in politics anymore?
It certainly goes through your mind. At that moment, I decided I was staying on, and I meant it. But it certainly went through my mind. There's no question. You have to. I didn't feel entitled to stay on as Minister of Justice and Attorney General. That is clear, and I'd had a good run, and I knew that I'd had a good run, and I'd spoken to people around me and my team, and they said, well, you can probably expect a change. I didn't expect a change that included me being left off the table, because I thought there were other places that I could have served.
So if you had been offered a different cabinet post, you would have stayed?
Oh my goodness, yes. Yeah,
you would have.
Yeah, I would have. I mean, it is. Each cabinet position presents a unique set of challenges, and I would have jumped at that. I tried to, as I said, I did my best to continue to be a good MP. I found it difficult, and
I want to ask one last thing. I don't know if you can answer this or not. So when you were told that you would no longer be serving as Justice Minister, do you have a private conversation with the Prime Minister, or did they send you a note?
No, I did have a private conversation. Yeah, it was the day before. And I had a private conversation.
Can you just, without revealing necessarily too much, tell us how that went?
Not good.
Yeah. David, you've done a great job, and sorry, we're going to make a change.
That's effectively it.
Is it?
Yeah, and that, I guess that's the truth, right? I guess that's the honest truth. And as I've said, the impression that I got from that conversation was that I'd done a good job, but got lost in a numbers game.
Okay.
Assuming that there's going to be a change in leadership atop the Liberals, could you be enticed to come back again?
As leader, no.
No. But
so that's off the table. We've established that.
That's off the table.
Yes,
I have said that. I aspire to be Minister of Justice. I don't aspire to be Prime Minister.
No, I'm not talking about Prime Minister. But should there be another leader and promising you the sun and the moon and everything else to come back to cabinet, could you be enticed?
There is, I think, the thing that has to be said first is we have a leader, and he's won 3 elections in a row. He's earned the right to decide whether he stays.
But eventually, he's not going to be there.
I mean, that's true for all of us, right?
Right.
Eventually, we're not going to be sitting at the table either.
Right.
But look, I like serving. I'm not sure that I will. I've promised to stay involved, and I will stay involved. I don't think, you can never say never, but I don't think I would ever come back as an elected politician, and therefore I wouldn't come back as a cabinet.
So relative,
I think I'm done.
Okay,
I'd stay involved, but I think
from the outside looking in.
Politics.
That's right.
From the outside looking in now, do you have the sense that there is, I don't call it a movement necessarily, but something afoot to say, you know what, maybe it's time for a change in that top job?
I think what you'll get from every person in caucus, and I think what you'll get from every person around the Prime Minister is he's earned the right to decide. We all see the polls. We see that the Liberal Party's behind in the polls. That's not unique for a government that's been in power for this length of time. You can dispute the numbers as being better or worse than other governments, but I think any government, what they really need to think about, and what leadership needs to think about, is putting together a series of policies and giving a series of policy options that points to the future. And if the Prime Minister comes out with a number of policy directions, says to the Canadian people, we want to move in this direction, here's what we've done, but this is where we want to go, I think it's incumbent on the governing party, the Liberal Party, to show why it wants to remain in power.
Okay.
And that's something that I believe in, and I hope that the party will do that.
So for now, you've returned to McGill in a certain capacity as an adjunct professor.
Hasn't been formalized yet. I have.
You're going to go back to teaching.
I'd love to. Yeah, I've resigned my permanent position. I was on leave. I had a public service leave, which is again a university policy that is very generous to maintain your spot. You don't get paid, but it maintains your spot. And so that was always an option. I love the classroom, and I loved doing the research. At this stage in my life, though, I think there are other ways to have an impact on policy. and remain in the classroom. So I'm going to go back and teach, but I don't want to be chasing
And
down
you've
research
joined the
money.
law firm Faskin.
I have.
And in what capacity?
Well, at this stage, counsel, and so I will be acting as a lawyer. I'm qualified in Quebec and in Ontario, but I will be practicing across the country. The three main areas of practice are in Indigenous law. And again, I've built up a number of relationships over the last 4.5 years with Indigenous leadership across Canada. We passed the United Nations Declaration on the Rights of Indigenous People in 2021 under my watch. And for the next 2 years, I co-developed an action plan to implement that, which was as intense as passing the legislation. And so I have a number of I think, positive relationships with Indigenous leadership. And we're looking at things like the critical minerals policy, where we're going to need to develop certain kinds of minerals for the new electric green economy. And much of it lies on Indigenous land. And so we will need to get to yes with development projects that have, according to UNDRID, free, prior, and informed consent of Indigenous leadership. And so that's the point, I think, to try to work out some really good precedents and good practices on the ground for these kinds of projects. The second is tech. So I've always had an abiding interest in technology. I was an IP professor at McGill for my whole career. And that's now morphed into artificial intelligence and blockchain and other things. And I'm hoping, I worked with Minister Baines as
Growth
his parliamentary
area for
secretary.
sure there.
Absolutely.
Yeah.
And again, hoping that I can have not just a positive impact with respect to clients, but also still have an impact on policy at the federal and possibly even provincial government levels. And then third, I'll help with government relations, which large law firms do. There's a set of conflicts rules that I will follow scrupulously, but those areas of practice.
Before we wrap up, I want to go back to where we sort of started, talking about what you said when you gave your speech on the floor of the House. You also brought up the idea of, and you reiterated this because I know you said this originally when you were the minister, this idea of the notwithstanding clause and its use. And you made a point of bringing that up during that speech. And I wonder why you felt that was necessary or important.
Well, I think it's important. We have a country based on the rule of law. We have a country based on recognition and protection of human rights, and those are framed in charters, right? And Diefenbaker had his Bill of Rights, and it was a good document, but it had a lot of weight, but it wasn't a constitutional document. Now we have a constitution, and that constitution has a charter, and the charter is there. So it represents to some extent the values of a nation, right? Irwin used to say when he taught me constitutional law that when we were talking about charter litigation, we were litigating the values of a nation. Well, the charter itself expresses the values of a nation, and same is true of the Quebec Charter as well. Same is true, I would argue, with UNDRIP, the United Nations Declaration of the Rights of Indigenous People. These are value-laden documents, and they mean something. And I think that means they're not optional. And if you take the view that you can use a notwithstanding clause to exclude something from the Charter preemptively, then you're taking the view that it's optional. I think the better view is, and I think this was the view of the people framing the Charter back in 1981, that there's a dialogue between legislatures and courts. Both of them have a fundamental role to play in the way we understand the rights that we have. I'll put it in Irwin's terms, the way we litigate the values of a nation. Legislature has the first cut at it, if you will, in terms of framing rights or in terms of framing limitations on rights, which governments have to do from time to time. I admit that. I have been part of decisions that did that. But then the courts will have their say. And if and when the courts have their say, government still feels that something was amiss, they will react to what the courts have done and possibly use the notwithstanding clause, possibly amend legislation, possibly abandon legislation, but in certain cases may use the notwithstanding clause. But there's been a first stage, a second stage, which then necessarily impacts the third stage. All of that's a process, and all of that's a dialogue in which people will participate, citizens will participate, courts will lawyers will participate, and that's a more fulsome process. You preempt all of that when you use the notwithstanding clause preemptively, and it really does mean the charter, or those provisions of the charter to which it applies, are optional, and I don't think that's the right view.
I will ask you one last thing as we wrap up, which is simply this. Looking back now, you've been a private citizen for 2 days.
2 days, yeah.
Do you have any regrets during the time you served that you were not able to do something you wanted to do?
I wish I'd finished that criminal convictions bill, the David and Joyce Milgaard Act. I promised David Milgaard I would get it done before he died. Got close, but it's in front of the House right now. And again, that's an important piece of legislation to me personally. Otherwise, there are other things I would have liked to have done, but I honestly didn't waste a day. I had a great team around me. We worked hard. We basically finished the substance of a 4-year mandate letter in 2 years. And so we pretty happy about that.
Now, far away from politics, heavy metal music still gives you some sort of emotional release?
Heavy metal,
You were a big,
alternative.
Alternative. People don't know this about David.
I'm well, Brendan Kelly does. He's one of your colleagues.
Yes.
But we talk about music often, Brendan and I. But you know, I'm a child of the 60s, so I had older brothers, so I got the 60s through my older brothers. I got the 70s when I was an adolescent. I got the 80s when I was a teenager, young adult, and then
blues.
The blues have always been there. The blues came in through early heavy metal, like Led Zeppelin and the Yardbirds and things like that. But now it's more. It's probably I listen more to a lot of 90s grunge and alternative, but also I'm on
Listen to 90s grunge and alternative now by choice?
I've got a lot of vinyl.
Really?
Yeah, I post my vinyls up on my Facebook.
Didn't know this about our
Did not
Justice
know this,
Minister.
no.
Yeah.
I had up in Ottawa. I have a lot of turntables, so I had a couple of turntables in my ministry in my Hill office, and we would celebrate bills with the team by spinning some vinyl and having some impromptu
One particular
parties.
group? Any favorites, personal favorites? Or office favorites?
Let's see. There's a lot of office favorites. More recently, I'm listening to a lot of softer, folky type stuff like Boy Genius and Phoebe Bridgers. But in terms of Bush and Nirvana and Hole, like all these, like Hole was a great band.
Who
It was
knew?
It was a Montreal connection.
I sort of knew.
We want to thank you so much for taking the time today.
Thanks.
Thank
We
you.
appreciate it.
Thank you.
And wish you the best of luck.
Thanks
Thank
very
you so
very
much.
Aaron. Thank you, Bill.
Oh, and of course, I should
you.
remind you, as our guest here at the Snowden Deli, you get to take home the lovely assortment of Danish that are
Perfect.
on the table.
Thank you very much.
And we encourage every guest, because I asked you before we started, you'd never been here before.
I haven't been here. I
So-
lived in the Plateau in Mile End for most of my life, and so
It's
downtown.
a rival smoke meat
Okay,
joint.
right.
He lives.
But every guest here as well gets to take home a smoked meat sandwich. So
Okay, perfect. I will do that.
It's a red letter day.
I'm going to compare it to my favorite in Villemart with
There you
Miche.
go. Thank you
Okay.
so much.
Okay, thank you.
That wraps up another edition of the Corner Booth from the Snowden Deli. We'll see you again soon.